Okay, well, good morning, good afternoon, and good evening, everyone who's watching us remotely. This is a hot topic session at the EURODIG, European Dialogue in Internet Governance. We're over in Brussels at the moment, and today we are going to be at this very early 8 a.m. time. We're going to be talking about the right to be forgotten, or the right to rewrite history as it might be. We've got a few people actually coming in the room now, so that's good. We've got a panel of people who know, I would say, quite a lot about the topic itself. Joining me, we have Caroline Koosmans, the head of legal for Google Belgium. And Caroline has a position, well, it's a position she's held since September 2012. She has an extensive career in internet and IT law, having previously worked as legal counsel to Google Finance, corporate counsel at Amazon, and legal and regulatory counsel at Tele2 KPN Belgium. She started her career at the law office from Stibbe in the technology and Technology, Media and Telecommunication Group. She studied at UCL in the UK, excellent, and at the University of Trento, Italy, and University of Antwerp in Belgium. We also have with us Joe McNamee, who is the Executive Director of EDRI. Let's see if I can see. Here we go. Here's Joe. EDRI, just a couple of words quickly about what EDRI does.
Association of Digital Civil Rights Organizations from across Europe.
Thank you. We have Irjo Lensipuro, who was a journalist. He has an extensive career in televised news. He has also been involved in internet governance for quite a few years, for as long as I can remember, have I been involved also for quite a while. In 1992, he joined the Ministry of Foreign Affairs of Finland, working successively at the press consulate at the embassy in Washington, D.C., and he also became the Director General of the Ministry's Department of Communications and Culture until 2005. Then he became the Ministry's ICT Ambassador and Information Society Coordinator, where he represented Finland in ICANN GAC. He held this position and also represented Finland for ECOSOC from 2007 to 2009. Next, we have Stephen Weiber. Stephen is... And by the way, I'm holding the camera at the same time, so that's why it's moving around at the moment. It's a little bit MacGyver-esque-like, but anyway. So Stephen is with the, is head of legal and public policy. No, it's the wrong person. Here we go. Is policy and research officer at the International Federation of Library Associations and Institutions, IFLA, based in The Hague. And he leads on copyright and on other matters. He previously worked on social and open government issues at the British Embassy in Paris, as well as on a wide variety of topics, including internet governance at the UK Permanent Delegation of the OECD. He studied at the University of Wales, Aberystwyth, and the College of Europe, Nathalie, one of them. And we also happen to have Elena Perotti, who is joining us remotely from somewhere on the American continent.
From Cartagena in Colombia.
In where, sorry?
Cartagena in Colombia.
Cartagena in Colombia, which is a lovely location to join from, but it is the middle of the night, so thanks for being with us at this crazy hour for you. You're the Executive Director of Media Policy and Public Affairs at ONE IFRA, the World Association of Newspapers and News Publishers. And Elena is responsible for identifying and studying major public affairs issues within the news industries, authoring reports and articles, animating debate on social media, which is why you're here, and educating staff and stakeholders. Elena is also in charge of interaction and liaison with ONE IFRA's governing boards, national and regional member associations, and with many international bodies. She holds a Master of Law in International Law and is experienced in media policy, senior management, global event organization, and public relations. So thanks for joining us, Elena, and thanks everyone.
Thank you for having me.
And thanks everyone here for waking up that early in the morning after such a wonderful party last night. So, the right to be forgotten. I'm not quite sure whether anybody needs to exercise their right to be forgotten about anything that happened a few hours ago, but it's one of these things that has divided opinion. Whenever I mention it somewhere, there seems to be some people who are totally for it and some people who are totally against it. And yet there are all sorts of cases where you might lean in one direction or another. Let's take two cases as an example. The first one being a 17-year-old person that finds out with a few friends some way of obtaining some alcohol, drinking beyond the usual amount, actually the normal amount, sorry, for a 17-year-old, and ending up with a cone on their head, perhaps being actually the son or daughter of a prominent politician, but finding that there might be some real worth in pulling their trousers or their skirt down in the middle of the street, and unfortunately in front of a police car, ending up being arrested for drunkenly behavior and disorderly behavior. Just a caution from the police, but a local paper picks it up and it ends up published somewhere. A few years later, they are out of university, they want to start a career, and unfortunately this page comes up on a search engine, and they really would like this to be removed from the search engine. So that's one of the cases. The other case, let's take a 23-year-old, and 23-year-old with, I would say, extreme tendencies or sort of unconventional views. Well, you'll judge for yourself. Pictured doing a Nazi salute with his friends, and a few years later, wishing to run for perhaps parliament and sort of evolve in the political game, and yet that picture comes up out there and is not particularly great for gathering further voters. Now that person really wants this picture to be taken down and wants to take it away from the internet or do something so that nobody can find it. So that's the two examples. Are they both liable for it to be taken down, or for it to be for them to be taken away from any search engine? Well, let's see what we can discuss here. There are pros and views against and views for it. I do recognize that a British Prime Minister recently was embroiled in a whole story of things that happened. I think it was Oxford University, and still remained Prime Minister, and everyone just had a good laugh. So maybe it's not that crazy after all of having putting your trousers down over in the middle of the street. But okay, let's move on, and let's start first with Caroline Kuzelmans from Google, who's going to give us a little bit of background of how, what this law, I guess, is about. So Caroline, the floor is yours.
Thank you very much, and thank you for having me here. Hi, everybody. I'm going to start with commenting on one of the most important, well, for Google as a search engine decision. It's the one from 2014, the Google Spain case against Mr. Costeja. We call it the right to be forgotten case, but indeed it's not really the right to be forgotten case. This case is really about the right for a European citizen to request a search engine to remove certain search results that show up when you search for a person's name, so a physical person's name. That's really what it is. And so what has the Court of Justice decided then back in May? Well, it said actually under certain circumstances, a data subject, so this person, can indeed ask a search engine to remove access to the website where certain information is held. And so it can be access to a press website, it can be access to any other website. Of course, this needs to be done taking in account certain principles. And so what has been clearly indicated by the court is that the search engine needs to make an assessment and needs to look at the information or the information that is available on that website, that to whom the access wants to be delisted or deleted. And so this information that is present on that specific website needs to be inadequate, irrelevant, no longer relevant, it's the same, excessive, but also taking into account the public interest on one side, so it's actually a balancing of rights that needs to be done, the public interest to have access to this information, but also, of course, the right of privacy of the data subject. So that's it. That's really everything we got. So already I think as a lawyer, like for every single word that I use now, loads of interpretations and discussions can be opened around how do you define this, what is this, just already what is too long, what is excessive, etc., etc. And then another part of it, this is like how can you decide what is in the public interest, and when can you decide that the balancing of these two fundamental rights goes in one direction or in the other direction. So it was quite a mission to set up and to make work. So that was an important, let's say, ruling for this discussion also. That's one, but I think there's two others that are also very important that came up lately in the highest court of justice, national ones, one in Belgium and one in France. The first one was issued in April in the Belgian Court of Cassation, where a decision was taken concerning, based on this concept of right to be forgotten, and the court requested an online newspaper to anonymize some of the archived news articles they had. So I think that's an important evolution or development. And at the same time, so in May, the French Court of Cassation had to decide over similar facts and decided just the opposite, that as certain information was processed with journalistic purpose, this right to be forgotten could not be used by a data subject to request the anonymization of an article, and both concerns sensitive data being criminal records. So I think this also highlights that the discussions that have been opened thanks to the Costeja case are still at the beginning, at the early start. So I'm very happy that I can be part of this panel where we are going to discuss certain things, because there's a lot still to discuss and to question and to think about. So I think that's certainly a very interesting discussion. As I'm talking about lots of subjects that need to further be discussed and developed, you might have heard that we are challenging also in court a request from the CNIL, the French DPA, to remove certain search results on a global scale and not only on a European scale. So for us, that's also one of the matters that has not been clearly discussed yet in the context of the Costeja case or the judgment, but that we think is important enough to bring back in front of the court, because there needs to be a public discussion also on that topic, where our position is that we do not think that one national judge can, based on his national legislation, decide globally for everybody what everybody can see or access on the internet. Now, also to explain how we reacted further to this Costeja decision. So I'm one of the lawyers from Google, and when we received the decision, I was like, oh my God, how are we going to do all that? And how are we going to be able to do this in a very quick way? Because we need to make sure that the data subject can contact us and can request this. And then when that request is done, we need to make sure that this assessment is done in a reasonable way. So very quickly, we've set up an online form. That's how we work. We like to work with online forms, because it's also the most efficient way to address a very high amount of requests. So we set up this online form. At that time, also, we needed to make sure that we asked the right questions to be able to do this assessment. but not too much because we have to respect the right of privacy, of course, of the data subject. So at that moment already the balancing was very much there. And then when we started to get the requests, we needed to set up a base of like guidelines of how are we going to assess and answer to these cases. What is important to know is that there is no machine behind all these requests that are sent in through this online form. And so every single case is assessed on a case-by-case basis. And there's also no categorization, so it's not like, oh, if there's that word in the request, then there will be a pushback, or yes, the removal will be done. To help us to understand a little bit better how to do this balancing of rights, we asked experts to give us some guidance, so we set up this advisory council of experts, maybe you've heard of, and we went to all the capitals of Europe to gather their advice and their remarks on the Costeja decision. So that was very helpful. Also, I think at the end of the year, Working Party 29 gave us also guidelines that we thankfully also integrated in the way we were looking at the request. So in the beginning, many people were asking us like, yeah, but how are you doing this assessment? Please be a little bit more transparent. So it was very difficult for us to already communicate about how we were doing that because we were still assessing everything on a case-by-case basis and seeing how things were going. We were also very much and on a very regular basis discussing our approaches with the local DPAs to make sure that we were all like in line or understanding how these things were assessed. And so thanks to this good relationship, DPAs have often come back to us to say like, we appreciate really like the very professional and serious way that you're addressing this request. It's not just we get a request and we push back, or we get a request and we remove it, don't even read it. That makes also that further to this interaction, these internal guidelines, let's say, on how to react to such requests continuously evolve. So one of the last evolutions was also concerning this access to this information from other European countries or from countries outside of the European domains. So, and that was also the result of discussions with the DPA. What do I mean with that? Because it can sound a little bit theoretical. For instance, if you requested, you are in Belgium, you request the removal of the access to certain information, so you request the removal of the search results, then we will, and if indeed after the balancing of all interests and looking at the facts, we decide indeed there is really ground for removal, let's remove, then we will remove the search results from the google.be, but also from the all the other google.european domain names. And even further, if through signals we can see that the person that is searching for the name of that person from Belgium, but is trying to access information through google.com, then if we see that that person is in Belgium, he will not be able to access that website. Of course, if that person goes to the US and does the same search on google.com, he will be able to access this information. So that's a little bit like the intermediary solution technical solution that we try to work out to find a middle way in between all the rights of the data subject and all the principles of law to come to a workable solution. I don't know how much time I still have.
Not much now.
Okay.
Very interesting though. So
and, yeah, maybe an important one. So I said that in the beginning we got a lot of questions like, how are you doing that? Which is the basis for you then to do removals or not? And now we're 2 years later, a little bit more than 2 years later, and we have a website, of course, as we also always like to put a lot of help pages online. You can, I don't know if you're connected on the Wi-Fi, you can see it now even. If you go to the Google Transparency Report, this is a report that we use for reporting all the kind of requests we get for removal, so from governments, even from third parties. We added a specific section for all the removals we receive based on the right to be forgotten. So when you click on that, you will see how many requests we received, how many requests we removed, and for consequence also how many we pushed back on. Mainly we pushed back because we didn't get enough information to do the assessment, or we think after balancing of the interest, we think there is a public interest to keep this information accessible. So you'll see all the percentages there in general, but also per country. But most importantly, also you see FAQs where we explain on which basis we do these removals. So that might be very interesting for you if you want to have more information on how Google is doing this assessment. I think it's a very, very clear web page with links to loads of information that might interest you. Thank you very much.
Thank you very much, Caroline. And we have had quite a few people join us since we started here. We're unfortunately, without a technician, we have to kind of work things out, as in do it yourself. Elena Perotti is joining us from, or has joined us from Cartagena in Colombia. And I was going to turn over to you, Elena, to tell us a little bit about the case with Le Soir, which is, I understand, maybe perhaps not under the same European law, but is sort of going a bit further even in Belgian law. So please, can you provide us with some details, and can you speak? Are you okay now? Have we lost Elena? Okay, so we have lost Elena. Okay, well, that's fine. I heard, oh no, and then it didn't work.
I'm back. Okay.
You're back on, but you're breaking up at the moment. No? Okay, so let's then move on to who wants to be next. Shall we go to Sergio or Stephen? Or Joe, sorry? Stephen is behind me. Yeah, she has dropped off.
Olivia, I'm here. I'm here.
Okay, Elena, let's try, yes. And please try and speak loudly because we have quite a large room, and I'm trying to do it with the microphones, but it's a little bit difficult, so we'll see.
All right, yes. So the case with Le Soir in Belgium, that was a decision that was taken by the Belgian Cour de Cassation, which is the Supreme Court in Belgium, at the end of April. It was the 29th of April. It is a very long decision, very complicated one. And as far as I am concerned, and the newspapers are concerned, I'm sure, very worryingly, I must say, because what the judge decided was to uphold the decision of our lower court, which had decided that indeed it was a case where the
and we've lost Elena again, it seems. Yes, with the internet, it's a little bit difficult. Okay, let's hope she gets back on.
Yes. Can you still hear me?
Yeah, no, we can hear you again. Okay.
Okay. Now, it is not based on a different law than the European law. It is indeed based on European law, but on the Belgian version of it. You know, the problem is that the directive, the privacy directive, which is applicable right now in Europe for another couple of years, 95/46, there's a problem that it has a journalistic exception foreseen in the directive, but this needs to be applied in internal law. The decision in Belgium did mention the decision of the European Court of Justice, but just in passing. The decision was taken, therefore, on internal law and on the Belgian constitution and their own privacy law. It is a worrying thing because the new data privacy regulation, which is going to be applied in a couple of years automatically in the whole of Europe, has specifically says that regarding the journalistic expression, that member states shall by law reconcile the right to protection of personal data with the right of freedom of expression and information, including the processing of personal data journalistic purposes. What does this mean? That we are likely to have 28 different versions of the journalistic exception around Europe. So this is something that, of course, is a reason of concern for newspaper and news media, not only Europe, but around the world. I have been contacted, for example, by our American members who were considering even starting lobbying state by state, the European members, to make sure that the journalistic exception is wide enough. The most interesting thing of all this Belgian decision in particular is that the European Court of Justice has said, in my personal opinion, very few clear things in this decision, in the Costella decision. But what it did say very clearly is that the right to be forgotten does not apply to news media. That was really clear. It was actually considered as one of the bases as to why right to be forgotten need to be applied to search engines, because it said, the Court of Justice said, it needs to be applied to search engines because the right holder might not have the possibility of erasing the bad news about him, because if it is in a newspaper website, then that newspaper website is protected by the journalistic exception. So this is the reason of concern regarding the Belgian decision. I would like to add, regarding what Caroline just said, that the territoriality issue was not considered at all in the decision of the European Court of Justice. They did apply European law to a body to a company which was not European. In this case, they extended the territoriality of their jurisdiction, of course, to an American company, which was Google Inc. But they didn't say anything about whether the information needed to be non-searchable only in France, only in Spain, only in Europe, or all over the world. This is a law that is being made. Actually, it is not law at all. It is just interpretations of the law that we are having from search engines on one side and from the data protection agencies on the other side. Not only the French data protection agency, of course, but most of all Article 29, which is, let's call it the jumbo data protection agency, the big one that represents all of them in Europe. So this would be my position about this.
Okay, thanks very much for this, Elena. That's really helpful, and it's another insight into actual cases that are taking place based on this. I'm going to turn to Joe now, and going to ask, perhaps as a follow-up, the point of view of EDRI and your point of view on these things, and perhaps, I mean, is there a right to privacy as well, though?
Yes. It's a very complex issue that you can, from a civil liberties perspective, you can take, in principle, diametrically opposite views and still say you're defending civil rights. To start at the very beginning, any interpretation by a court which would rewrite history would not be in line with European law, with the ruling, or with anything we would want to accept. I think I know you're trying to be provocative with the title, but I think it's not really in line with reality. We also need to be careful of our vocabulary. What this is about is delinking a name to a result.
Exactly.
Now, if we start with the broadest question, if a search engine is producing results that are prejudicial to me or you, that are inadequate and out of date, is it reasonable that that wrong should be remedied? And that seems like a reasonable thing. And Google indeed has come to that conclusion itself independently of the ruling. It applies a global right to be forgotten with regard to revenge porn, for example. And there are a lot of people that would find this to be not a terrible thing to do. Google also was faced with a very interesting challenge that I've only heard of recently myself, a thing in the US called mugshots websites. So in the US, if you get arrested, your photo is taken and it's a public record. And some ingenious, awful people came up with a business model of creating pages with the pictures that are on the public record and using search engine optimization to make sure that if you search for the person, they were on the top of the list. And this is it's just appallingly evil as an idea. And Google took the view not to delink the people's names, but just undo the search engine optimization and push them down to the oblivion that's known as page 3 of Google search results.
I thought 30. Not, but 3 perhaps, yeah, might be. And again, it did this globally. It did this globally because it saw a particular harm, and it wanted to remedy that harm. I'm not going to give an opinion, but this is, you can work out yourself whether it's reasonable or not. On other issues in relation to copyright, for example, it imposes American copyright law globally, and it de-indexes rather than delinks, de-indexes completely 1 million URLs a day in order to implement US copyright law. So in this context, it seems broadly coherent that that requests should be made, or can be made, or considered by Google. The challenge is achieving predictability, achieving accountability, achieving a balance that would be considered reasonable. In this environment, you have to, in the absence of a more clever solution, find a balance of incentives that leads Google to be approximately on the right line. There was a case that was decided coincidentally less than a month before the Google Spain case that is very relevant, I think, but I suspect nobody else thinks, to the Google Spain case, which is the Kino.to case, which involved a non-specific injunction being imposed on an internet provider to limit access to a particular website. And the ruling that the court came to was that the company should impose a measure which is not so difficult to impose that it undermines the company's ability to do business, that achieves the best result possible for the complaining rights holder, and where the individual, the customer, who's having the restriction being imposed on their connection, would have the potential under national procedural law to complain about any undue interference with their rights. So there's sort of three different pressures leading to an appropriate result. That's not what we have, interestingly, from Google Spain, which was decided a few weeks later. In the Google Spain case, Google has an interest if Google says yes, this is a fair complaint,
then that's the end of the story. Google has its business interest, but it's got no particular legal problem about saying yes once too often, or 10 times too often, or 1,000 times too often. If it says no, then the person who's made the complaint has redress to the National Data Protection Authority. And I think the percentage, but somebody next to me knows better than I do, the actual number of complaints about Google saying no is very, very low. So the balance, the structure of the decision-making process is seems to be somewhat off balance, and more peculiarly seems to be off balance in relation to the European Court's own position on the challenge of private intermediaries making decisions that have significance for other rights such as freedom of communication. So I think Google will have to, for the good of us all, invest a lot more in cases in order to tease out all of these issues.
Okay, thanks very much for this, for the points that you've raised here. I'm going to turn to Irjo Lensipuro, and I think that looking at the requests for delinking, because I think that's what we're really talking about now, it's delinking rather than taking down the content. A lot of it actually is based on news stories, articles, journalism. You stand in the accused corner. Journalists report on things. I mean, what does this mean for the press? And I guess as a journalist, how do you feel about having content that has been out there, that used to be printed in the past, and that would not be somehow taken down or taken away from these archives that you would find in libraries, for example? How do you feel about this?
Well, thank you. As we heard from Oliver's introduction, those days when I was an active journalist are have been passed for a long time. However, I have been dealing with journalism and media most of my life. So in those days when I was an active journalist, we didn't have search engines. We hardly had any internet. So that actually, when investigative journalism at that time really meant going to dusty archives.
It's the same.
Yeah.
Maybe you can use two mics. Maybe, I don't know. It's this one is better. Yeah, this one works.
So in those days, investigative journalism really meant investigating and going to dusty archives and libraries or whatever, and not just going to a search engine. So I think the important thing, as you pointed out, we talk about delinking, and we are not talking about destroying historical records, because the originals will always remain there. Now, I think that in theory, this sounds scarier than it is in practice, because, I mean, if you take this sort of orthodox point of view, when the freedom of expression and freedom of journalism is supreme, then of course any tampering with that is bad. But I mean, I think in practice, when you balance these two things, privacy and freedom of expression, I think that in practice most of the time you arrive to tolerable results. However, we're talking about journalism and journalistic purposes and so on and so forth. And I have to say that I belong to the old school of journalism, where whatever we published, especially in television news, public television, we had to have some significance, some relevance for the society as a whole. We didn't do things just for sensation's sake. And of course, it's entirely different for those so-called yellow papers and yellow websites that just want to have sensation after sensation. But when it comes to public figures, for instance, it's when if you can dig out something with this, like you refer to this Nazi salute and so on and so forth, that's really what they say, gefundenes Fressen, the sort of really something that is fantastic to publish. The more responsible journalistic approach would say, what kind of significance for the actions of that politician today does it have? And so, yeah.
Okay, thanks very much for this, Sergio. And you have accused libraries of having dusty archives, and I guess I have to turn over to Stephen then, who will be able to tell us a bit how this whole thing affects libraries and the archives, which are now e-archives, I guess.
Yeah, I'm flattered by the idea of libraries being a form of dusty Google, which I suspect we won't be taking that up as a mission statement for the International Federation of Library Associations. I suppose, I don't know, given that you can look across from this room, obviously for Elena and on the webcam you can't see this, and you've got the National Library just opposite. It's always worth underlining that libraries have been there making information available and searchable for years. So maybe the dusty Google thing isn't such a bad description in some ways. Clearly they also have a responsibility for maintaining the historical record. Libraries are all about access to information, access to knowledge, and if this complete, accurate as far as possible historical record isn't there, then you don't have much in the way of access to knowledge. And of course, you don't have much of a historical record if there's no freedom of speech in the first place, or if freedom of speech has a shelf life where you can speak, but then it just disappears after a bit, it self-destructs. We'll come back to the question of digitisation later, as of course digitisation is one of the tools used to make sure that things printed on paper that simply aren't going to survive more than a few years can actually be preserved in the long term. Of course, it's also worth underlining that libraries are there for their users. Libraries are all about also making sure that people feel safe online, and if people feel worried about going online because they feel their privacy is going to be compromised, then they failed. So libraries find themselves in this position of having to really balance these two things, like all of the actors here. So I think then to underline, I think it's been, as a lot of people have talked about, clearly in the whole, there are two massive principles at play. It's quite difficult. You can't go entirely to the end of total privacy. You can't go entirely to the end of total freedom of speech. Neither are absolute rights. So there has to be some sort of intelligent thought about doing it. When I put out a tweet yesterday talking about this session, someone came back asking if there'd not yet been a non-scummy request for a right to be forgotten, which is probably unfair. There will be, for every victim of revenge porn or trolling, there's always going to be someone who is a dodgy director of a company who wants everyone to forget that they stole money a few years ago, which probably makes them unfit to be a director. So on the library side, the priority is, the starting point has to be maintaining the historical record. The starting point has to be to have a historical record there. So I know we've talked about the fact we're not talking about deleting things. We're not talking about a right to erase stuff. And for us, I think we'd be definitely very concerned about any possibility of actually deleting things from the record. Again, the Lesoir decision, this was actually talking about deleting things from an archived newspaper, not just deleting them from search results. That is a worry.
Would you be ready to go with a pair of scissors and start snipping things off your paper archives?
My colleague here is more freshly out of library studies. Would you be happy with scissors?
Oh, well, the thing is, when you have things in libraries, you make a selection of what to keep and not from the beginning, so you just don't keep everything. I think in relation to the question of press ethics and what you publish and what you decide to keep in the collection that's the selection you normally do in libraries. So cutting things up afterwards might be just a new version of that. I mean, you could see it that way, I guess.
It could be seen that way. I think it would.
Just not ever the case where any librarian has ever done that.
Well, librarians do throw things away regularly. But I mean, I guess when it comes to unique material, that would be more archivists who do that. Those libraries, I guess. Yes, sometimes you decide you don't need to keep certain things. Yeah. But then that's an important decision.
Often for purposes of space and cost.
Yeah, well, also collection building. What is relevant and what is not? This information overload. So that is a big question, which is also relevant to this. Like, is there a need to keep all the information? And sometimes there is. For example, you have the question of precedents and what is news and what is just sensations. I mean, is there any historical value in keeping sensational news in that sense? Well, news. That's a really good question as well.
And I guess that's a big difference now from being able to store things electronically, where there's so much you can store and you can just put it in the archives, whilst libraries were somehow restricted in the amount of space they had. So as you said, there had to be a selection of what was going to go into the archive and what was going to be thrown out.
Well, yes, there's also the question of even if you have unlimited space, you don't have unlimited search capacity. You have to be able to navigate the digital space as well. But that was a bit of point to the right. We forgot that question we should probably submit to other issues. But I think that's a thing to.
I have a question on that also. How are you going to search? Well, that if you can't use search engines, like all the information is there, but how do you find it? Like that was one of the comments that was made, I think, in Spain by one of the experts. Like if you need to remove certain search results, and so you can't really use digital tools because the results will be different. How
you can have private search engines.
How can you?
We're talking about Google, not about libraries internal systems.
Yeah, but
okay.
I mean, like if you look at the system, like if you have to search, if you to alter your search system because certain results cannot be made foundable, it's just
that's not how it works.
But that's not.
And that's Ian Brown, by the way.
I'm not asking for an answer. I'm giving the question.
When your question is on a false premise, that's what I'm saying.
No, I don't agree with you. That's true. So the question is.
We won't get anywhere with false premise questions.
Yeah, but sorry, that is not my opinion. I'm just bringing you a question that was brought by the expert council, and so I invite you to read it if you want to understand the premises of that question.
Oh, I do.
Okay. Ian, can we just please, in a moment, and we'll pass the mic over to you. You can express yourself on this.
Thank you.
Okay.
So yeah, but if you want, I will share it. It's an interesting question that she says, like, if we push this through, then does that mean that at a certain point we will have to use like medieval tools to actually access certain information? I'm not talking about Google. I'm just talking about the comment she made, and I think it's an important one to think of also.
How do you mean medieval tools?
Like if you can't use digital search tools, all the information is there, and we all agree that we don't want to remove certain stored information. How will we be able to find it? Will we have to use paper stuff?
Well, metadata works the same way always.
Yeah, but
so you
just think about that. That's a question she raised.
So let me just jump in and actually give the floor back to Stephen, because we've kind of stolen it from him, and I see the debate is already starting up, and there's a lot of hands coming up quickly and so on. So quickly, before war starts.
I'm very happy that this is my presentation. This is led to comment, even if it's from a colleague. But anyway. So clearly, yeah, starting point is historical record. Obviously, on a case-by-case basis, there are very good reasons for getting rid of things because of making things undiscoverable, because they're untrue, illegal, illegitimate, too personal, sensitive. We have a policy statement on this agreed by the global library community. There is also clearly a point that the process of taking decisions on whether things should be delisted needs to be seen to be transparent. Otherwise, it will tend to lead to calls for much clumsy regulation. I think Joe's point about from the pre-Costeja judgment, where any solution actually needs to be workable, is really important. I think libraries contain vast numbers of biographies, archives, documents like this. And if there is a clumsy approach to this, then it's simply not workable. It's only the biggest that can actually manage to apply the rules. Clearly, on Le Soir, as mentioned, There are questions about the fact that, at least in the Belgian judgment, the point they make is not so much. One of the key arguments for the ruling was that it was a rediffusion of old information due to digitization. And so if we're digitizing old things and then calling that a rediffusion of information, then that poses a massive question for all digitization work, because suddenly then something that may be 50 years old can be still treated as being new and raise issues there. With the global data protection regulation, clearly there's an article saying that archiving, preserving for the historical record is something that is justified. There's an exception for this. The definition of who then should have access to things through libraries has been left unclear for the time being. So that's going to be another potential battlefield in the next couple of years, and definitely something worth following, because then if there's a rule that everything is there in the library, but you need to be in category A, B, or C in order to actually get in and look at it, that's also something that has the risk of having 28 different setups across the EU and restricting access, which is allowed in one country. Thank you.
Thanks for this. Elena Perotti has a comment on the Belgian decision regarding Le Soir. Elena?
Yes. Well, my comment about that is that, in my opinion, if this decision were to be appealed in front of the European Court of Justice, I believe the European Court of Justice would have to send it back and reform it, because it is the only way that it can be coherent with the decision that the European Court of Justice has taken in the past, with the decisions taken in the past in the respect of the journalistic exception. I also want to say, regarding the debate that happened before, that the argument that delinking news from search engines means basically to it is only used very often, which is because it is a good image. It is like having a library but burning the little papers that allow you to go through the library, so you cannot find any book that you want. That is not really true, because the decision from the Court of Justice just says that when right to be forgotten is granted, then a query with that person with the right holder's name and surname will not give you that particular article back, but different queries would still reach that same article. So that because the news is still published online in the news media website. So it is a whole cycle that actually allows the news to still be there and still be perfectly findable with all the original information. And that is why it is really important to preserve at least that particular point that the European Court of Justice made, that the news needs to stay entire and full online. That was all.
Okay, thanks for this, Elena. I'll turn over to Joe now, because you put your hand up a bit earlier, and I think that we can now start the debate and discussion in the room. And of course, I've already got two people in the queue. I know Ian is going to be in the queue, Farzaneh, but also the gentleman on the left here, on my left, sorry. Joe.
Well, what I was going to say was the last thing that was said, which is the content stays where it was. It can be found using any other search term other than the person's name. If the fox that jumped over the lazy dog doesn't want to be identified as that, and Google agrees, then searching for instances of jumping over lazy dogs will still find the fox. So the notion that we become some medieval digitally annihilated ignorant world is slightly overstated.
Okay, thank you for this. Let's start with a gentleman on my left. I don't know whether we can have a microphone coming over to you. And if you could speak, also introduce yourself, please.
So I just actually wanted to quickly pick up on the point made by the last talk. Also, actually, I have comments to all of them, but all of the speakers, but I'll keep it very short, so I'll just pick two. But just on the last one, the Belgian case, of course, it's about anonymization. It's about anonymizing the name in the article. It's not about removing the archive. And indeed, like putting archives online, in my opinion, should be considered as a rediffusion, because you make it available on a much broader scale. So you cannot just do it without giving it proper thought. There's this whole level of practical obscurity, right, with old archives that is removed basically when you put things online. And then just to pick up on Joe's point, that when, like in specifically Google's and the delivery case, because right to be forgotten is of course so much more than just Google, but everyone focuses on that. That users do not have a right of appeal because they will often originally not even know that search results have been delisted. So my initial reaction to that argument was that, yeah, okay, but we as users of Google do not even have a right to access it, to have certain information put there in the first place. Now, of course, that doesn't mean that it cannot be impacted, this right to access, by someone else exercising their right to do this. But of course, then again, like Google and any other search engine influences these search rankings on so many different ways already. So it's influenced by so many different factors already, for copyright, for revenge porn you mentioned, by search engine optimization tools outside of the power of these search engines. So there's so many factors at stake. So I really wonder to what extent is this, because the numbers actually are not that big if you compare it in the grand scheme of things, to what extent are search engine users' freedom of expression, freedom of information rights really affected by this? Just an open question, yeah.
Okay, thank you. Joe, any response?
I think it's a very fair comment. Insofar as the court recognized that there was a freedom of expression issue, there is one. And insofar as it exists, to some extent, it needs further thought. You're not wrong.
Okay, thanks for this. Let's turn over to Professor Brown. If you could, Irio, could you sort of send the mic over to, or at least one of them that works?
Yeah.
And are you okay with extending for another 10 minutes or so? I know that there is a main plenary starting and so on. So if you do have to go, then of course you're not stuck here. But it'd be great. I think the discussion is going now. So go ahead and please introduce yourself.
Thank you for a really interesting debate. It's so rare that I go to these meetings and hear new things, but I heard these things from all speakers, which is wonderful and very thought-provoking things. And thank you also for taking my immediate interventions. All I wanted to add was, I agree with what Jeff was saying, that it's important we think about the broader impact on the right of search users as well as people being delisted. And one way to do that would be for the search engines, as they already do when it comes to copyright takedowns, to publish much more information in the transparency reports about what's happening. So that way, all of us can see if it's really sort of starting to get out of control and something more needs to be done.
All right, thank you for this. Let's then move down the table over to Farzaneh.
So my question is, if you have a right of appeal, if someone can challenge your decision, I'm talking about Google, if someone can challenge your decision for delinking, and because I think that's quite important. And also you said that you might decide based on public interest to delink or not to delink. What's the definition of, so Google has a definition of public interest, or what is public interest?
No, well, so you mean is there a right of appeal for another person than the data subject? Yeah. Well, nothing is foreseen like that, but I think that's like the only people now that's what I see from the discussions. Like, so when we discuss certain cases with DPAs, because certain data subjects are not happy with the fact that we push back and we say no, or we don't want to remove, and we have using these reasons why we will remove this. The DPA will have the facts, the information they received also from the data subject that appeals to them. And normally it's either the DPA or Google that is also looking at what is then the public interest? So it's either the DPA or Google that needs to look at that. For instance, and I think your question is a good one, like, but how do you organize that in practice? But I think that indeed, a very important point that needs to be taken in consideration. And for the moment, it's only the DPA or Google that has the opportunity to think about it and to bring arguments in that sphere. Now, what is public interest? It's a good question. This is one of the broader principles that has been set out by the European Court of Justice, that we are trying to define as we go and to understand, because in every single law system, public interest can be seen as being filled out in a different way.
Okay, thanks for this. Jeff?
Yeah, sorry, I'm going to abuse of the fact that I still have the microphone here. I had a conversation not that long ago with someone who noticed that in Google's transparency report, which, I mean, I agree with Ian that there's still room for a lot more transparency, which, okay, it's maybe not an easy exercise, but I think Google has been a front runner in other areas, so I really think that there's some. Anyway, on the statistics, that there has been sort of, in the beginning, there was a fluctuation of accepted, not accepted cases, and now there seems to be really a stagnation for 1.5 years already. So the person was really wondering if it's more of an internal, just, okay, if we come to this sort of compliance rate, then we probably won't have any issues with DPAs.
No.
It's really striking that it's really, it seems to really.
As you could see, we don't have problems of having issues with DPA. I think that in France we've demonstrated that very well. Not that we like it, but it's not that we like. If we think the battle is fair, we will go for it. No, it would have been much more easier for everybody that we would have had the decision, and every time we would have a request, we just would have removed.
But that's not in your interest either. Of course, Google wants to give.
Of course. But I mean, like, if you look at it like that, that would be the most easy way. We would not have had to, set up all these teams to look at every single case to make this balance of interest, etc. So no, there are no internal quotas of like let's try to get there and then everything will be solved. I think it's more the requests are changing. People understand better what this is, when they can request it for. Also, the DPAs get a little bit more of precedents to rely on to understand we too. So I think it's more like people, and I don't mean only the data subjects or users, I mean like every person that is a party or is involved in this whole procedure, start to get a better grasp of what this is and how this is best dealt with, but it's not quotas. And I can tell you, I still have very vivid discussions also with our privacy commission here in Belgium. They once said, we would like Facebook to talk to us like Google does, like they said that in the press. So we talk a lot and sometimes we agree to disagree also on certain points, but we take a lot of time, everybody, to make sure that we discuss these things and that we explain why we push back.
Do you communicate the accepted cases also to Google, or only the
DPA?
Sorry.
So what
or
happens,
only the rejected?
I can explain what happens, for instance, here in Belgium. So we get a lot of requests. Some people that get the pushback are not happy. They either go, because in Belgium you have two options actually. You can either go to the DPA or you can go directly to the courts. So we have some court cases where we will discuss this without passing through the DPA. We have some cases that go to the DPA. The DPA understands also what kind of information is needed to make this assessment. So often they are a very good intermediary to ask the data subject, but if you provide that information, the assessment can be done in a better way. then we have cases where we get an escalation to a DPA based on the extra information we receive. We say, okay, indeed the data subject has a point, and we agree with the DPA that this should be removed. But we have, as often we have also cases where we say, no, sorry, we still think that this is a pushback. And then it's free to the DPA to give an advice to the data subject, and then the data subject can go with that. That's the system in Belgium. Can go with that advice to the courts and then start a procedure. So there is no, let's say, there is no formal reporting towards the DPA, but there is there's enough cases that we are all aware of, and that is enough an example for the DPA also to understand how serious we take these things and on which basis we do pushback. What makes it also more interesting for us, because we can have more and more interesting discussions also with the DPA, because they also develop their precedents, and so it leads to let's say intellectually legally interesting conversations, but without losing out of sight that this is a very private matter and it's not just an academic discussion. It's really about the life of people.
Okay. Thanks for this. Elena has a comment on the appealing of a decision. Elena?
Yes, I was just surprised of hearing that it is a bad thing that nobody aside from the data subject can appeal Google's decision. I mean, for any crime, for any court decision, you need to have some sort of direct interest in the thing you're suing for. So that seems to me like obvious that only the data subject can appeal against Google's decision. I would assume that maybe a good NGO of civil society could appeal against Google decisions, but it really doesn't seem to me like the big problem of the situation. Again, the big problem of the situation is that the news needs to stay intact. That is for sure. And there's another big problem is that what happened in the end was that the balancing between two very important rights and two human rights on the same level, which are freedom of expression and privacy, have basically been outsourced in the situation that we are with to a private company, which for the moment is doing, I think, a decent job of doing this, but it really shouldn't be with it should be with courts.
So if I can just comment?
Yes, please, go ahead, and then we'll have Ian Brown.
I'll just take the mic.
Yeah.
I agree with you. And it's not just appealing to Google's decision, it's also appealing to the escalation the DPA wants to do to push back on our decision. So it's, I mean, like, okay, we take this decision because the court has decided that we had to take this decision. So that's on your second comment. Like, I understand the comments you make, but, you know, this is the situation as it is further to this decision. So we as an entity have to work with that situation. But I think indeed it would be, it might be interesting to see how other parties that will be impacted by this removal can be involved. There again, you have huge privacy issues, because who will that be? How will you be able to contact these people? Like, for a lot of crimes, for instance, it can be the victims, but maybe also family of victims. It's a whole discussion. Yeah.
Okay. Ian Brown, and then we have to go. So, Ian?
I just very briefly to add to that, I think it's admirable that Google put so much effort into doing this in a way that tries to balance all the interests concerned, and that I think we've already heard good suggestions and could probably develop more about how. I mean, by the way, I think Google, if it wanted to, should be recompensed for the money that it spends on that public function. But more importantly, I think there are ways you could develop mechanisms over time to try to make sure that these interests aren't being balanced too strongly in either direction, whilst taking into account very important privacy interests, such as having, a European review body that looks at the sample of the cases each year and tries to judge, did the decision, whoever was by the search engine, the DBA, the court, go the right way.
Okay, thanks for this. Any last?
just quick.
Okay, very quickly, because we are 10 minutes and I think a lot of people have to go. So please introduce yourself.
I'm Sasha from the University of Sarajevo. Actually, the question is, would it be possible for me to engineer what Google gives to the world about me by a couple of carefully based complaints about the results? So basically, if you search for me, you get the results that I want them to look.
There are companies that are already doing that. So it's it's like often people that was even before the Costeja decision, like it's like internet reputation companies, I think, and then they instead of going on trying to delete, they create positive, and by creating positive, that will end up on page 1, and all the rest will go to page 30.
Okay, thanks. Any last words from our panelists before we close? No, I know that everyone has to go. So I think that's it. I'd like to thank Stephen, Caroline, Joe, Ilio, who's had to run away, and of course Elena, who is probably longing to go to sleep now in a few minutes. So thanks for joining us, everyone. Thanks to our audience for having participated quite actively in this. I've certainly learned a lot of things. And what we will do will be to try and get the recording to be linked to the wiki page for the session. And this has been recorded, so that's it. So thanks to everyone, and this has been really, really enjoyable. So thank you, and goodbye. Have a great day, and have a good night as well.
I think it is,